The newest CSPA memo just dropped from USCIS. This is effectively going to overturn so many cases that got previously denied. I'm going to walk you through the most important thing you need to learn from this memo, how it relates to the two other memos, and what are potential future memos that are going to come out. So let's get to it. Hi everyone, my name is Joseph and I'm the managing partner here at Zan Associates, where we solve legal problems with creative solutions. There are a lot of kids that are supposed to be able to get their green cards with their parents, but because of a technicality, age restrictions, they are over the 21 years old by the time their parents got their green card. Immigration law, in all its wisdom and justice and fairness, have certain parameters in which you can freeze the child's age earlier. So even though they are presently over 21, you can freeze it and they can go back in time. Last year, they issued these two memos and it effectively changed everything, the law of the land, and because of so much confusion and unintended consequences, now they issued the newest memo. This memo clarifies that under circumstances where the immigrant visa becomes available and then unavailable, USCIS may calculate an applicant's age, CSPA age, using the date an immigrant visa first became available. The first two memo from last year effectively allows for USCIS to take a look at the dates of filing chart, which is so much more beneficial. It freezes the age so much sooner, so such that we have 30-year-olds that were able to freeze it back to when they were 20-year-old. But here's the problem. Back then, 10 plus years ago, it was available, but because of the priority backlogs or processing times, it became unavailable. And then it became available and then become unavailable. Under the immigration law, if something becomes unavailable and then becomes available again, suddenly your age is frozen at the new date. And then if it becomes unavailable and then becomes available again, your age is frozen at the new date. And it kind of makes sense, right? It's like if it became available and you didn't apply for a green card, well, why should we freeze your age at that time? However, the situation now is that people couldn't have filed all those years, and that's why they aged out and they never got the green card. This only became the law last year. So this new memo clarifies we're able to use the initial date. Of course, you still have to prove you couldn't have filed all of these times. Well, you know what? That was the purpose of the second memo from last year. The second memo clarifies that USCIS may excuse an applicant's failure to satisfy the sought to acquire requirement in cases where the applicant did not file their adjustment of status application because USCIS could not calculate their CSPA age or would have calculated their CSPA age to be over 21 years old under the prior policy. So in summary, the first memo in February of 2023 allows USCIS to use the dates of filing chart as opposed to the final filing chart to be able to freeze a kid's age. And some cases you can freeze it by 10 years. The difference is like 10 years plus. So this is extremely important to calculate. The second memo essentially establishes we understand you couldn't have filed within 1 year to seek to acquire your green card because this law literally just came out last year. So for the past 10 years, you couldn't have known. So it fulfills that. Now, the third memo that just got released essentially states, even if it closes and reopens again, you can still use the original one. With these three memos, you put it in your adjustment of status application if you are here in the United States. If your parents got a green card, but you couldn't get it at that time because you were over 21, maybe you're 22 at that time, maybe you're 23 at the time. If you're somehow able to reverse time and just freeze your age a little bit sooner, then you can potentially get a green card, even if you're 30 or 40 now. This memo makes a tremendous difference for anybody who's in the United States. This is the CSPA. Literally, these memos are just coming out now. What's missing from these memos? Still a lot of stuff. What if you got denied overseas? What if you are overseas? Can these memos change the determination of overseas? Can the consulate still use these memos and give you a green card? The answer is no. These memos only apply here in the United States. And so if you're outside of the United States and you can't get in, well, tough luck. What if your parents abandoned the green card? Can you still get it? That's still a big question mark, right? So there's a lot of situations that's still unclear. We're still waiting for new guidance from USCIS. Anytime there are new ones, I'm going to be sure to make a video and explain it. Thank you for watching. Take care. Bye-bye.